I'm John Ketchum, Director of Cities and a Senior Fellow at the Manhattan Institute. I appreciate your joining us this evening for this preview of the 2026 Supreme Court term brought to you by the Manhattan Institute and the Federalist Society. The Manhattan Institute and the Federalist Society are two of the foremost organizations dedicated to the preservation and defense of freedom through the legal system. The Manhattan Institute's legal policy team has established itself as a recognized and respected voice in federal litigation, consistently filing amicus briefs in the most consequential cases. MI's work would not be possible without the constant support of our trustees, and tonight we're honored to be joined by Trustee Kenneth Gilman. I would like to recognize also MI's former president, Mr. Larry Mohn, who's here with his lovely wife, Kathy. Larry, thank you for your stewardship of this institution. And we're also delighted to have MI Senior Fellow Danielle Sassoon with us, former acting U.S. Attorney of the Southern District of New York. This evening, we will discuss a bevy of key constitutional questions before the court this term, including First Amendment protections against censorship, time, place, and manner restrictions in federal elections, campaign finance restrictions, redistricting, girls and women's sports, and executive power. The court's decisions this year will shape the policy landscape and have political and institutional ramifications for years to come. Joining us to help make sense of the court's docket are some of the conservative legal world's sharpest minds. Judge Michael Park of the United States Court of Appeals for the Second Circuit, and Jim Copland, the Manhattan Institute's Director of Legal Policy and Senior Fellow. Thank you both for sharing your expertise with us this evening. We regret that Saritha Komatireddy, who is scheduled to speak this evening as well, is unable to join our discussion because of an unforeseen circumstance related to the government shutdown. And Ilya Shapiro, MI's Director of Constitutional Studies, is delayed in transit but should be joining us momentarily. We greatly appreciate your understanding and your patience. We'll see if congestion pricing really can get him here faster. In the daily scrum of political and legal fights, it's important to keep sight of the slower but more durable wins that the conservative legal movement has secured in the courts, especially over the last few years. This session may well provide a new slate of victories for freedom, order, and enduring American principles. And with that, I'll pass it over to you, Jim. Thank you all.
Judge Park.
Thank you, John, and thank you to the Manhattan Institute and the Federalist Society for putting on this event. And welcome to everyone here for joining us this evening. This is an exciting time of year with the baseball postseason. New Taylor Swift album just dropped. The football season's underway, college and professional. And today is the first Monday of October, which marks the official beginning of a new Supreme Court term, as many of the law nerds here well know. Last term, we saw a lot of activity on the Supreme Court's emergency docket, as well as a number of big cases. Supreme Court struck down universal injunctions. It upheld a Tennessee ban on puberty blockers and hormone therapy for minors. And it held over a challenge to Louisiana's congressional map, among other cases. This term seems in many ways like a continuation of the last term. And with the emergency docket over the summer, in some ways, there wasn't the usual break that the Supreme Court sees over the summer. But the court is picking up on election-related cases, transgender issues, and presidential powers, in addition to a number of other high-profile cases. And so you'll be hearing about a number of these different cases in these areas. And so with that, I'll turn it over to Jim.
Thank you, Judge Park. Very much a pleasure to be on a panel with the judge. I've known the judge since he was a 1L. We overlapped in law school, and I was actually his the Coker Fellow in Constitutional Law, a teaching assistant for the late, great George Priest. not sure why we didn't discourage him from going into the law, but I will say that, he was one of these students you get. I mean, the teaching assistants are basically sort of teach research methods, teach legal writing, and any of us who's written a lot for a living knows your writing can always be improved. The problem with Michael as a 1L for me was, it's not that it couldn't have been improved. I just didn't have any confidence as a 3L how to improve it, because I didn't feel like his was so good out of the gate, and so it's hardly surprising that he's done as well as he has and is now here on the Second Circuit, where I once clerked. I'll start with just sort of the cases that we're seeing right now. I'm not going to go into depth in them because they're not really in my space. I do legal policy, law and economics work, securities regulation in particular, and civil litigation, civil liability, a longstanding issue for the Manhattan Institute. Ilya is our con law guy who does the amicus brief, so I speak more to federal agencies, although also to Congress and the White House and other places. And Ilya speaks more directly to courts. Not that I'm never involved in these, but this is his thing, and the con law, the Supreme Court is his bailiwick. He will get here. He's on the way. But today we saw two cases argued via Real v. Texas, which it's a crim law case. This is something that our other panelist was going to talk about, someone who's actually in the Justice Department. But this is a case that is probably of interest to lawyers that practice in the crim law space, not as much generally, but it's sort of a Sixth Amendment question. What happens when you break for the night? So you're sitting there at trial, you break for the night. What are the boundaries of how you can or can't talk to your lawyer? Because of course we're all guaranteed the right to counsel, so the Constitution says that. But normally you don't get to chat with your lawyer while you're on the stand, right, and adjust your testimony. So what happens when the court breaks for the night? Federal courts and state Supreme Courts have differed on this. There's a couple different sort of bookend cases that the Supreme Court's done. They're going to just try to figure that out. And that's about all I can really talk about with that one, because it's really outside my field of expertise, but it's an interesting one. The other one is something that is more adjacent to the stuff I've worked on for many years, or the Manhattan Institute's done for many years, and that is Burke v. Choi, which was argued this morning. And a lot of us have worked for years on things like medical malpractice litigation, and we've done Trial Lawyers Inc. reports on healthcare, and we've talked about, we've done empirical studies on the cost of medical malpractice litigation. And so a lot of states have adopted various rules under state law to try to rein in, out of control tort awards that ultimately hurt access to healthcare for their citizens in that state. Now, those of you who are lawyers know that there's state law, then there's federal law, and you sometimes get into federal court through diversity jurisdiction or other reasons, where you're in federal court and applying state law. And the question is, do these state law reform rules apply in federal court? And so they're going to be thinking about that. I know which way I want the case to come out, but I'm not sure what the right legal answer is there. But that was argued as well this morning. We're going to have a couple more tomorrow morning. One of which Ilya will be talking about at some length, one of which is a double jeopardy case, Barrett v. U.S. The one he'll talk about at some length is one of these sex cases. We have sort of like executive power, elections, and sex. Those are the real big themes of this term, at least so far. And Charles v. Salazar, which is this sort of conversion therapy. It's a First Amendment case, really, but is one of these sort of sex gender cases. Ilya will talk about a little bit. Before I get into some of the big bucket cases, and I am a little bit consciously stalling, given that when I get to those, I'd love to have Ilya here just so he hears what I say, because I know he's got thoughts on these cases too, even though we've divided them up the way we have. But there are a couple cases that are in this sort of civil litigation docket that is of interest of me, and it's of interest of Manhattan Institute traditionally, going all the way back to the late Peter Huber and Wally Olson and some of their original seminal books in this space. And so, Haines Celestial Group v. Palmquist is a diversity case coming out of federal diversity down in Texas, and it's a lawsuit against a baby food manufacturer, and they joined Whole Foods, which is a retailer in Texas, among other defendants there, to try to defeat diversity jurisdiction and get into federal court. And so, Wally Olson wrote about this way back in the litigation explosion in '91. I mean, this is where plaintiffs are going to shop their cases to the forum they think is going to be most favorable to their claim. And so a lot of times there's a question, is it in state court or is it in federal court? And to get diversity jurisdiction, you have to have what's called complete diversity. And so if you can add on a retailer to a claim that's principally against a manufacturer, you can defeat complete diversity and keep it in state court where maybe it'll be more favorable. This is sort of the thing that's going on here. What happened here was it was removed for diversity, and it was removed for diversity jurisdiction. The trial court, the federal trial court, said this was improper or fraudulent joinder. In other words, this wasn't a legit joinder, and then dismissed the case on the merits. And then it went up to the Fifth Circuit Court of Appeals, and the circuit court took this case and said they disagreed on that diversity question or the joinder question, and then vacated the judgment and went back down. And so that's what's coming up to the Supreme Court, is like, how does that actually work? And there's some difference among the circuit courts and how that works, which is a good way to get in front of the Supreme Court because they want sort of a general national standard on these sorts of questions. The administration is taking the claim that they want a ruling where basically if there's complete diversity at the time the judgment accrues, then that judgment holds and you don't have to vacate it, which is a judicial economy question. We'll see how the court fleshes this out. But these cases aren't enormously common, but they tend to be, some of them are big dollar cases, and we've done a lot of work on this in the class action and context, and it's big in a lot of these sorts of product liability, consumer fraud sorts of cases. So it'll be an interesting question to see. The other one, which at least the younger folks in our audience will have an appreciation for, I think, is Cox Communications v. Sony Music Entertainment, and this is the copyright liability to an internet service provider, and this is basically about these sort of download streaming type services, or you download music. The Supreme Court some years ago decided the Groxer case. This is a parallel sort of case, and it flows out of a 2019 jury verdict of $1 billion against Cox Communication, finding it contributorily and vicariously liable for copyright infringements on over 10,000 works on its platform, right? So this is the sort of situation, is like, are we gonna be able to hit this internet service provider because things were getting downloaded on its platform and make them held accountable? And so that is coming up as well. The cert was granted in June on it. The respondent's brief isn't in yet, so we don't know a complete picture on how it's going to be framed. But the question really is, it boils down to two main questions the court's going to be considering. One is contributorily liable, and the vicarious liability was tossed below and it wasn't granted cert on, so it's really this sort of contributory liability question. Do you need affirmative steps, affirmative intent to foster the infringement as part of the standard there? Do you need proof of that or not? And the other question is going to be how willfulness under the statute applies. In other words, do they have to have knowledge that someone else is infringing, or do they have to have knowledge that they themselves are doing something that's unlawful? Obviously, this is going to have significant, it's a $1 billion verdict, significant implications for how internet companies permit activities on the internet, because if that liability flows through to the internet service provider, the tendency is going to be to shut a bunch of stuff down. Whether that's good or bad may depend on your point of view. I mean, obviously for the Sonys of the world, for those who are the copyright holders, they'd like to shut a lot of this down. All those teenagers out there that are downloading this stuff would like it not to be shut down. And it's going to hinge on the doctrines and the statutes, but an important economic case. So those are the economic cases. I guess I will start then on some of the powers cases. And basically, they're in two buckets here, and they're sort of the buckets that fit the first two chapters of my 2020 book, The Unelected, which I subtitled Legislating Without Congress and Administering Without the Executive. And so they're two sort of separate buckets, right? The first is what Barack Obama called pin and phone legislation, from the White House. The second is the president's control over the executive branch. That is, the president is the titular head of, the only elected member of, and how much can the president control that branch? And so I'll go to the second one first, and this is really the president's removal power, the question of the president's removal power of various people who are in the executive branch, but not the president's cabinet. And these are the so-called independent agencies, at least this variation of these cases is the so-called independent agency. We've got two cases which are bubbling up out of the so-called emergency docket, and Ilya will probably talk a little bit about that, I think, in more detail, because there's a lot of discussion about the emergency versus the regular merits docket. Basically what happens in some of these emergency cases is, a judge does something, the court's got to decide. These have massive sweeping implications, and so we've got two cases that are now docketed, scheduled for oral argument in December and January respectively, that the court's going to be considering in parallel, Trump v. Slaughter and Trump v. Cook, each of which involve independent sorts of agencies. One is the Federal Trade Commission. The other is the Federal Reserve Board. I'm sure, certainly on the latter, you've seen some of the wrangling there around the Fed, which is the Cook case. There's slightly different postures as of right now, in that there's the stay actions that are at issue. The individual Slaughter, the defendant, has been able to be removed by the White House in the one case, and then the Federal Reserve Board Governor Lisa Cook has not been removed. So the state postures are opposite here, which is, I think, a pretty good tell of how the court is thinking about these. We also have a lot of good evidence, including from this summer on another emergency docket case, that gives us some good evidence about what the court's thinking here. The seminal case here that underlies all this is a case called Humphrey's Executor from 1935. And this arose from the Federal Trade Commission in the Roosevelt administration, and the Roosevelt administration came in and said, we want to put in our people. We don't want these other people that we don't like. Their general philosophy of government in general, and then there was this guy Humphrey, and his executor, his estate. We don't get the details of that per se, but what the court did at that point in time, which was hostile to the Roosevelt administration, was say, no, this is an independent agency, and Congress can, as it has done by statute in this context, specify that the removal power can only be for cause, not at will, so that the elected president can't just come in there and shake up these independent agencies. And there were various rationales under this, including that the agency wasn't purely executive, but had quasi-legislative and quasi-judicial powers. The court has been chipping away at this over the last 15 years. First with two statutes that came about after the dot-com bubble crisis and then the financial crisis, Free Enterprise Fund v. PCAOB, which flowed out of the PCAOB, the Public Company Accounting Oversight Board, created under the Sarbanes-Oxley legislation that flowed out of the dot-com bubble, Enron, WorldCom mess, right? And basically you had there a dual level for cause protection that was set up between the SEC, which is an independent agency with 3 and 2 partisan allocations with staggered terms and things like this. And under it, you had the PCAOB, which also had a for-cause protection. And here's Ilya. So good. I've gotten too far into this stuff that he's going to like to talk about potentially as well. And he can correct me if I'm wrong. So welcome, Ilya Shapiro. I'm outnumbered now with well, I guess we have 2 Princeton and 2 Yale people on the block now, depending on how you count where we went. So the So anyway, so they did that with a duel. A decade later, Sela Law v. NLRB. They had by CFPB. The question is, if you have just one person in charge instead of this sort of bipartisan board, then the president has to be able to throw out the head of the CFPB, which was, of course, created in the Dodd-Frank law in the wake of the financial crisis. So these were new laws, creating new structures, and Humphrey's executor was getting narrowed down and limited. And this summer, we had another emergency docket case in May, I guess it was a little before the summer, Trump v. Wilcox, involving Gwen Wilcox, a member of the NLRB that Trump wanted to remove. And without resolving the merits, the court stayed the lower court's reinstatement order and allowed the president to remove this NLRB member. This was over the dissent of the 3 Democrat-appointed justices. And so that's what we had there. It is interesting that they signaled in these cases, they had a paragraph in here talking about the Federal Reserve is different. And so I do think we may see a split in how these cases, Slaughter and Cook, are resolved. The interesting thing with Slaughter is because it's the FTC, it's pretty much on point. I think it's going to be harder to distinguish Humphrey's executor, I think, than in the ordinary case where it's a different agency. So we may see Humphrey's executor be overruled or at least narrowed or clarified or et cetera. I think with Cook, the Federal Reserve Board is different. I mean, listen, this controls the money supply indirectly. It sets interbank lending rates. It can,
Well, the administration is treating it as differently. That's why they're removing Cook for cause, or trying to.
Exactly. So fair point. So they may just say they may remand for a discussion on what qualifies as for cause, et cetera, right? So with the Federal Reserve case, they signaled this summer that going back to the Bank of the United States, you remember from your regular history class, there was a back and forth over the Bank of the United States. And so some of this is sort of well settled. They clearly don't want to get in a situation where presidents can come in and fire all the Federal Reserve governors. Here we've got a situation where this governor was claiming, primary residence status on mortgage applications for a house that wasn't her primary residence, so that was fraud. And does that constitute for cause removal? So a little distinct, but I think there are parallels. It's going to be interesting to watch these cases.
I thought it was interesting that Slaughter squarely presents the question: should Humphrey's executor be overruled? But the court added the second question, which is, can federal courts even prevent the president from removing officials? And
right.
But then in Cook, that's exactly what they allowed to stand. So I think, as you mentioned, Jim, that may signal that this Fred carve-out could be coming.
Yeah, I think there's going to be some carve-out, and they may I don't know if they're going to de novo try to figure out on their own, what the right for cause is, or remand on it, et cetera. But it will be somewhat interesting. Ilya's got things he wants to say. I've been talking a while, so I've got a couple other cases I want to talk about. But if you're ready, I'll hand you to Ilya because he may opine on these. He's also got stats on the court. He's a court tracker and can sort of set some of the broader picture here. So glad to have you.
Yeah. Thanks. I've never, walked in late and had applause to that. So hope it wasn't sarcastic. But there was supposed to be another panelist, as probably was mentioned, and I tweeted just this morning, like, has anyone noticed that there's a government shutdown? Like, I live inside the Beltway, so I know federal workers who are like considered non-essential, so they're on furlough. But like in the real world, does anyone even notice the government? And apparently it's now affected me because one of my co-panelists isn't allowed to be here because of it. Small price to pay if it saves the taxpayer some money, frankly. Although I haven't met Saritha yet, I'm sure she's wonderful and would have wonderful comments. But anyway, so look, today is it's like the first day of school for court watchers, right? The new term, it's so exciting, they're all back, except this year it didn't feel like there was a summer break. Right? We had those big cases come down the end of June, and then they kept working. I mean, they were all traveling and teaching and on book tour and whatever else, but still, like once or twice a week, we'd get some order in some really important thing that would make front page news. I never got to catch my breath. And I think, we're debating what to call this other docket, right? It was the shadow docket, but they're not really doing it in secret, so the emergency docket. But some of these things last a long time and aren't real emergencies now. Interim relief docket. I think it's a period of flux, but where we're gonna end up is that, like, we're going to take away the line between the dockets. It's just what the Supreme Court does. And sometimes it's just like short things, and sometimes they put it on the calendar. Like some of these cases that Jim has discussed were originally on the emergency, interim relief, whatever docket. Now they're here. The other thing is that the statistics really belie the vibe. You might hear that this is a very, very conservative court, and that it's hopelessly split, polarized, just riven with dissension, when fewer than 10% of the cases were 6-3 with the Republican appointees over the Democratic appointees. Justice Kagan was in the majority more often than Alito and Thomas. So again, lots of stuff going on here, but the half dozen top headline grabbing cases, sure, that's going to be lots of political stuff to analyze, whatnot, red meat. But when you look at it overall, the court is a court, and that's why even at a time of historically low institutional trust and public confidence generally, the court still does better than whether it's the presidency, Congress, other federal institutions, the media, organized religion. I mean, any institution, and the court is other than the military, the court is pretty much doing better. Okay, those are kind of my opening remarks that are now inserted randomly into the middle of the program. So Jim was doing the business side and the executive power, and I'm going to do sex and politics. A set of gender identity related cases. The first one that's going to be argued, I think, next week or tomorrow, Childs versus Salazar, is sort of the inverse of last term's big case, Scrimeti, where the court allowed Tennessee and half of the other states to maintain their ban on medical and surgical procedures to treat gender dysphoria. Well, here we have Colorado and not quite half the other states banning talk therapy for gender dysphoria, except they call it conversion therapy, except it's not banning all talk therapy, it's only banning talk therapy that's not affirming the gender transition, quote unquote. So that's why this is only superficially, I think, an inverse of Scrimeti. First of all, because it's not an equal protection or due process sort of case, 14th Amendment. It's going to be a First Amendment case. It's going to be therapists who do nothing other. I mean, they're medical doctors, they're licensed, all of that. And the state is arguing, well, we're not regulating their speech, we're regulating their therapy, their behavior, their conduct. Just like we give them licenses, part of that is making sure they're not, charlatans of some kind. But the problem is, as I said, they are allowed to use talk therapy for gender dysphoria, but only in one direction. So this is not just a First Amendment case, but it's a viewpoint discrimination First Amendment case. And Manhattan Institute filed a brief representing perspectives of Jewish and Muslim therapists. Very interesting stuff, at least to me. I'm just the lawyer, just plugged their interesting material into a brief format. So I think it's easy to predict. I think that this is going to be Colorado's law is going to fall. The other gender or sex cases are sports, prohibitions on biological men in girls and women's sports. One case out of Idaho, one case out of West Virginia, one case involving high school, another involving college, one that was decided below on Title IX, the federal law that allows equal educational opportunity for women, including sports. The other decided on constitutional grounds, equal protection. But in the end, this again is easy to predict that the court did not take these cases to affirm the lower courts that had blocked the state laws. Everyone's looking at Gorsuch because he wrote Bostock, which is the case 5 years ago that read gender identity and sexual orientation protections into anti-discrimination law. But he has made clear both that he still believes that he was correct in Bostock, and that Bostock is limited to the text of Title VII. So just like in Scrimeti, where he didn't say anything and didn't write separately and fully join the majority opinion, here maybe he'll say something, but it's not a Bostock case. It's, you know, men and women are women, and you know, even if Justice Jackson, who spoke more than 50% more than any of her colleagues last term, and typically begins her questions with "help me understand" or "I don't understand," you know, maybe finally this case will help her understand what a woman is. Okay, moving to politics, and Jim has a politics case as well. That's going to be my segue back to him. One case that the court heard last term but couldn't make a decision on, they set for re-argument. This happens every now and again. It's a redistricting case out of Louisiana. And districting cases are always sort of interesting, but very technical. Very technical both on the facts, how are you drawing these lines, what's the purpose, what's the evidence, who said what in committee, all of these, you know, things, and on the law, because the law is very convoluted. And a few years ago, the court threw up its hands and said, we are no longer going to be adjudicating partisan gerrymandering. That's not a constitutionally cognizable claim, maybe under your state constitutions or something, but the U.S. Constitution doesn't say that, you know, you have to protect Republicans or Democrats or anything like that, so we're getting out of that game. But in the context of using race for drawing districts, there's kind of been this Goldilocks standard. You have to use race a little bit to allow or enable racial minorities to elect candidates of their choice, is the jurisprudential language, but not too much, because then you're, you know, discriminating based on race. You're violating equal protection, or under the 14th Amendment, or the 15th Amendment's protection for voting without regard to race. And here, Louisiana, which has 6 congressmen and is about 40% black, drew congressional lines where one of the 6 districts was majority black. And they got sued, and the court said, no, you have to draw a second majority-minority district. So they did, and they got sued for using race too much. So you know, the court was evaluating this stuff and decided it couldn't resolve it because they kept raising these thorny issues of, is this jurisprudence about voter dilution claims? That is, that you're diluting voters by drawing maps in certain ways. Under Section 2 of the Voting Rights Act, these claims might run afoul of the 14th and 15th Amendment, so it set re-argument on that question. And I think what it's ultimately going to do here is vindicate Justice Thomas's long-held view in this area, which is that they shouldn't be in the business of this Goldilocks direction of saying you've used race enough but not too much, whatever. There's no standard here. I mean, sure, you can still use Section 2 to say, you know, they're blocking precincts, or they're closing precincts in black areas, or denying, you know, Hispanics the right to vote in some way. Sure, you can make those kinds of claims, but not this line drawing, voter dilution. Going back to the dirty bargain in the 90s in Georgia, where the GOP colluded with the NAACP to draw very safe white Republican districts and very safe black Democratic districts. So anyway, all of that, I think, and the jingle standard, if any of you have gone into this area of law, I think that's all going to be thrown out.
I was going to ask, do you think the Supreme Court will get rid of jingles or strike down Section 2 of the Voting Rights Act?
Well, it won't strike down Section 2 because it can still be used, again, in you know, discrete issues, specific allegations of direct racial discrimination, but I think they will get rid of the ability to make voter dilution claims under Section 2. So whether that requires overturning jingles, it might just say it's no longer cognizable. So it's like you'll still see that red flag in Westlaw when you look up this line of cases, but not because it's been abrogated or something rather than overturned. And then a case that's going to be argued this Wednesday, Bost versus Illinois State Board of Education. So we had, this was districting. I'm going to talk about election regulation and then turn it to Jim for campaign finance. We have the triple crown of political law, all different aspects of it presented. Bost asks whether candidates for federal election can challenge state time, place, and manner regulations. So the Constitution says Congress sets the election, you know, second Tuesday in November, but states do time, place, and manner. So, you know, some states have paper ballots, some states have machines, some states used to have levers, and they, you know, have precincts in different ways, different rules about like how far away from the thing. I mean, there's different things that states set. In this case, what about mail-in ballots, right? The Constitution's elections clause also says that there is one election day. Well, Illinois said that you can count mail-in ballots received up to 2 weeks after Election Day if they've been postmarked by Election Day, or if something else. Anyway, the thing is illegible, but it's been signed. All these kind of rules about how you can count mail-in ballots up to 2 weeks later. And a federal candidate for election in Illinois wanted to challenge this, and he was rejected on standing grounds by both the district court and the Seventh Circuit, saying that his challenge was unripe, he sued too early, and regardless, he was in a safe district, he won going away, these mail-in ballots wouldn't have affected his race anyway. So effectively, what the Seventh Circuit is saying is that you can only bring these challenges in the aftermath of an election, because you can't bring them, so he was too far ahead. You can't do it right before an election because there's this thing called the Purcell principle. You can't upset the election rules so close to an election. So you can only bring them right after an election that was hotly contested. That sounds like a recipe for disaster. I think the court is going to, they might not even rule on the merits of the mail-in ballots, probably won't. They'll probably just say, of course you have standing. Yes, these are state regulations, but the Constitution is what gives states the power to regulate, and federal candidates clearly have an interest in that. So this is not going to clean up all of our election challenges or legitimacy concerns or what have you, but it will enable timely rather than after the fact litigation over these issues.
Awesome. And the third of the trilogy of sort of politics cases coming before us is...
I didn't give Jim any of the sex cases, took them all for myself.
Yeah, he took the sex. Is the NRSC, the National Republican Senatorial Committee, v. FEC. And this is the campaign finance, campaign spending case. The latest in a long, long line of these cases, dating back to the 1976 precedent many of you have probably heard of, Buckley v. Vallejo, that was after the Nixon-Watergate campaign finance reforms, the first sort of Supreme Court step into this area. And what they did in Buckley v. Vallejo, they threw some of it out, they left some of it in. They said, well, no, you can't limit expenditures by the campaigns. You can, however, limit contributions because there's at least the appearance of impropriety or maybe quid pro quos going on or things like this. And we've come down through to the present day. And so what we've also seen is this sort of division, the questions of soft money, and in this case, the specific of sort of like coordination between the party and the candidate. There's a pair of companion cases, Colorado 1 and Colorado 2 from the late 90s, early part of this century, that basically divided these sorts of things up, whether the party can have sort of independent expenditures but can't have coordinated expenditures. There's a bunch of rules flowing out of that. Of course, we had the McCain-Feingold campaign finance reforms come in, much of which were upheld in 2003 by Mitch McConnell v. FEC, substantially, though, then scaled back in 2010 by Citizens United, which, of course, prompted President Obama to call out the Supreme Court in the State of the Union and Justice Alito to react, and he hasn't been back to the State of the Union since then. Judge Park, clerk for Judge, then Judge and Justice Alito. And that was basically on this notion of, well, yeah, this was about Hillary the movie, and the FEC was trying to say, well, that's an electioneering expenditure, and Congress can ban Hillary the movie right before an election. Well, that can't be the right rule, and so they asked for rebriefing and decided that case. There've been subsequent cases, one involving Ted Cruz, a McCutcheon case, striking down aggregate contribution limits, all this sort of mess on it. And so the question here is this sort of party candidate coordination line going to survive? Now, just from a policy standpoint, this has had some really interesting and I would argue pernicious sort of reactions, this sort of semi-regulated, semi-free speech regime where, the parties have been very, very weakened by all this to some degree, right? The parties can't go out and raise money and be as strong as easily, and so you've got a lot of sort of outside groups that can speak more easily than the parties, and, we see the impacts of that in Congress, although there's a lot of other factors underlying some of those trends as well. Just from a legal standpoint, the Manhattan Institute, Ilya did a brief with Brad Smith, my friend from Institute of Free Speech, a former FEC commissioner, in this case. And, we have a couple of things. One, just saying, politics is the political speech is the core speech. The court's got no business, the Congress has got no business policing this stuff is the core argument, but also re-examining some of these sort of empirical guesses dating all the way back to Buckley v. Vallejo that have been embedded in this area of law, sort of, what are the impacts of this going to be, the sort of purported quid pro quo. This stuff's actually really important. I mean, when the judge I clerked for, the late Chief Judge Ralph Winter, when he was a young law professor at Yale, he argued Buckley v. Vallejo before the Supreme Court on behalf of Jim Buckley. And one way he persuaded what was a pretty liberal court, he had clerked for Justice Thurgood Marshall when he was a judge, and one way he persuaded them was by just looking empirically at the way this law was structured. And what they found was, lo and behold, the expenditure limits that they're setting was just below the minimum spend of a successful challenger to incumbent in the prior election year. Well, that made William Brennan and Thurgood Marshall put their ears up, and so you got a result that at least part way was free speech protective there. And so what Ilya and Brad do in our amicus brief is sort of go through some of the evidence of what's actually happened in these states that don't have these sorts of limitations. So we actually have some sort of empirical evidence that may come into bear, or at least may make some of the justices think about it differently.
The point being, the only acceptable reason currently on the books for having campaign finance, political speech restrictions is to prevent corruption or the appearance thereof.
Right.
In the party candidate coordination area, who's corrupting whom, right?
Yeah. Yeah, and so you have to have these theories of it. Well, it could be that the theory is you could be having a donor who really, really wants to buy a candidate, and he's going to do that with the party as a conduit. And so what the brief says is, well, we've looked at all these states, and even the FEC's own expert can't point to a single example of this in the multiple states that allow this sort of thing in state elections.
So if these courted party expenditure limits are caps are removed, what's going to happen? The parties become
I think the parties would gain more strength in their ability
relative to the super PACs and other independents.
So instead of the super PACs, instead of every special interest which can do this on a pretty unlimited basis, the Republicans and Democrats or any other political party here in New York, there's several of them, could raise money on more equal footing, which I think could actually be a good thing, right? Because parties have an incentive to win elections. It probably pulls you closer to the median voter, right? And political theory, the special interest groups, they're single interest. I mean, they have the right to speak too. Don't get me wrong, but I think disabling the parties, particularly in these legislative elections, has created a lot of situations, that create dysfunction in our legislative bodies that haven't been doing their job very well, especially at the federal level. So one more case I haven't gotten to, which is the other one, which I'm sure, in terms of economic impact, perhaps the biggest one, and that's Learning Resources v. Trump. And that's the other sort of executive power case from chapter 1 of my book, legislating without Congress, although here there is a congressional statute that's being pointed to. So there has been a delegation of authority to the president under the 1977 International Emergency Economic Powers Act, which has been the principal hook that the administration has pointed to for these Liberation Day tariffs and the broad sweeping tariff authority that's been asserted by the White House, since April in particular. And so the question here is going to be both a statutory one and a constitutional one. There's also sort of a jurisdictional question, like which is the right court to hear it. Probably less interesting for us. I think the more interesting thing here is what the merits are going to look like. We've seen, of course, the court stepping away from areas where the president, with a thin reed sort of statutory hook, can assert executive authority. We saw it, in the last administration with things like eviction bans, student loan restructurings, and what have you. We've seen the major questions doctrine more formally articulated in West Virginia v. EPA. A lot of this goes all the way back, more than 20 years. Justice Scalia's quip in Whitman v. American Trucking, which was, I guess, 2001. Congress doesn't hide elephants in mouse holes. Now, the issue here is, this statute is pretty broad, and it's designed to give the executive branch pretty broad emergency powers when emergencies happen. The question is, oh, we've got a trade imbalance, or we've got fentanyl coming in, or whatever, enough of a predicate there for that. I guess what I'm suggesting here is I think the justices are going to be skeptical on this one, which doesn't mean they're going to give the White House a clear loss. As Ilya suggested in a City Journal piece, which you've got in front of you, particularly the Chief Justice doesn't like direct losses, particularly when it comes to signature policies of an administration. We saw that when he upheld the Obamacare, the Affordable Care Act.
Here it actually fits. A tariff is a tax, and so justified in the taxing power.
So I think the chief, at least, would love to resolve this in a way that doesn't greenlight the president on this, but also doesn't deal a clear 100% immediate defeat to his signature policy effort, notwithstanding that, Obamacare, at least there was a statute that was actually enacted, right? This one, it's a statute 48 years ago designed to rein in emergency powers of the White House. Now, there are other tariff statutes out there. My con law professor, Jed Rubenfeld, opined in the Free Press, our friend Barry Weiss, who's a wealthier woman today than she was yesterday. He wrote for her and say, well, you could point to Smoot-Hawley, that's pretty broad, but then the question is, does that still apply when there have been subsequent laws enacted? There may be arguments here to be made on it. It is clearly, I think, the Congress does, and there's plenty of statutes out there where they talk about the tariff power. We do all the way back to J.W. Hampton, which is sort of the seminal case you get in law school in your case book when it comes to things like non-delegation doctrine. Yeah, Congress has delegated tariff power, and it goes all the way back to the beginning. There's other cases. And that was sort of an intelligible principles test, but Congress hasn't really formally invoked the non-delegation doctrine since the 30s. My guess is they will avoid it here. And Ilya,
they had a prime opportunity last term with a case with low political salience involving the Universal Service Fund. If you look at your cell phone bill, one of those little line items, which Congress just said, yeah, FCC, you can do whatever you want there and however much you want. And then they further delegated it, the FCC did, to a private organization. And the court thought that there was enough of an intelligible principle. If they didn't revive non-delegation there, they're not going to do it with the tariff. Now, they might use major questions or something else to give the administration at least a partial loss, but probably not non-delegation.
And they may, as Ilya suggested in his piece, they may remand for definitional clarity at the lower courts to sort of keep this percolating. Now, listen, if you're a trader here in New York, you're an investor, and you're worried about the uncertainty of all these tariffs and things, that wouldn't be a great opportunity, although maybe it is if you can make money off of the uncertainty. I don't know, right? But my guess will be they'll try to come out with a way. We saw this with the case, the deportation case earlier this year. We will come out with a way where the administration is reined in, and they're not going to greenlight it, but they may try to preserve a situation where it's not a direct confrontation. We'll see how they can split that baby. It's a tricky case, right?
Did this case come off the emergency docket? And I guess this goes to an observation Ilya made about, are they just kind of merging now?
Partially, I think.
Yeah. There's two different cases.
Right. There's an en banc Federal Circuit opinion,
And it's not that one.
They're consolidated.
Yeah.
Actually, they're not consolidated. They're going to be separately argued, but like back to back. And one was cert before judgment. So technically, they're on the merits, but accelerated.
Yeah.
Again, it doesn't really matter. If you're just a layman watching and you see a headline, Supreme Court does something, you're not like, wait, was that on the emergency docket or was that on the merits docket?
it's different than these sort of removing a person case. So I mean, they're not going to resolve it. I don't think they're going to resolve this without a big opinion. It's not going to be.
Yeah.
They're going to come. There's going to be big opinions in this. My guess is the chief will take it, and if he can get a majority to back what he wants to do, and they'll try to do it in a way that doesn't inflame the president too much, but lays down some clear guardrails that you've got to have a clear statutory hook for this. And now lower court judges, not your court, but lower court judges involved here, you got to take a look at it. That's probably what they'll try to do. So
Let's take some questions. Do we have microphones circulating? How's this working? I'll just mention while she's advancing. Raise your hand if you want to ask a question. Oh, sorry, you're the moderator.
Raise your hand if you'd like to ask a question. Yeah, why don't you just find the closest hand? Great, and please speak into the microphone.
Sure. I'd like to ask you to follow up on the removal for cause. You could have the statute simply read for cause. You could have the statute that provides some element of standard like malfeasance, etc. Do you see a distinction between the two? And in either case, what would justify a court second-guessing the president on whether that standard was met?
But yeah, I mean, this is the question. I mean, this is sort of what Judge Park was talking about in these cases. I mean, you've got a different sort of stay posture here, which shows they're thinking about it a little differently in this case. My guess is on that one, at the end of the day, they may punt down for some for-cause determinations as well and string it along, right? But
there is jurisprudence that it's incompetence or malfeasance. You don't have to necessarily define those terms. But there's a further question of the allegations are she fraudulently filled out mortgage applications, but she did that before she was a Federal Reserve governor. Does that matter? So they might define some of these things and then send it back. I don't think you'll see dueling PDFs analyzing her mortgage applications in the court's opinion.
For the judge, a lot of cases on the emergency docket. How do you make sense of these things when you don't have a written opinion and you're faced with, wow, this is what the court just came down with, and I have no understanding as to why. So what do you do?
Yeah, that is a good question, and it's something that we're working through. There was one motion we had in a funding discontinuation case, and there was about 2 sentences in a Supreme Court opinion saying this has to be channeled through the Federal Court of Claims. And we didn't really have a lot to work with there, and so we took different views, but we're interpreting very little, and so that makes it more difficult for us as well. But that said, I understand that this is the type of thing that is difficult for the court to process on a short time frame without the benefit of multiple courts of appeals decisions, a bunch of amicus briefs, and sort of the best briefing that the parties can provide. And so, they're doing what they can, and we're doing what we can, sort of in the interim and the interim before the interim, until the regular process can play out. But it is sort of an interesting jurisprudential thing that we're all figuring out. So.
There's a relatively short, relatively accessible law review article by Will Bode, Sam Bray, and Richard Ray about how precedential are these interim orders and what should judges do with them. And it's a lot of, it's kind of hedging because we don't really know and there's a lot of flux, but the thing is these interim orders are in emergency postures, and so, yeah, if you get a case on all fours with the same procedural posture, it's more binding than they did something about, like you said, a one-sentence thing about that goes to the Court of Federal Claims. That might be more binding than simply, okay, that's stayed, without opinion. Well, what does that exactly mean? You just automatically stay these things, or what? That doesn't give you much to work with.
Yeah, because a lot of the cases too the decisions are, some of them are unreasoned at all, and so there's really nothing to work with. And then some of them are sort of initial assessment of the likelihood of something, which is different from an actual analysis of the merits.
And people shouldn't jump on these judges for being cautious here, right? I mean, in the Slaughter case, for instance, I mean, the lower court, they weren't going to look at the NLRB decision from the summer and, off the emergency docket and then, say, oh, the court's implicitly overturned Humphrey's executor when this is right on point. No, of course not. They're gonna apply the precedent that is there on the books and wait until the Supreme Court moves, right? Which is what they should do.
To what degree do you think the acumen and skill of Justice Department personnel are going to influence the outcomes of some of these cases?
I mean, good lawyering matters for sure. I think the SG's office, the Solicitor General's office, has been very strong, both in choosing which cases to take up to the Supreme Court. That's what's largely responsible for the administration's upwards of 80% win rate on the emergency interim relief docket. They're not taking everything that they lose up to the court. And in just the quality of their briefs. These are serious people who are in that office. Lawyering matters, and regardless of kind of the how do you put it, the atmospheric surrounding certain U.S. attorney issues and whatnot, when it comes to appellate advocacy, I mean, it's been top notch.
Yeah, I mean, I think the lawyering that matters perhaps the most is sort of the lawyering that predates the case, right? The lawyering that's done within the administration as they're figuring out what actions they're going to take, right? I mean, after that, all these things Ilya's talking about matter, but once you get it in front of the court, yeah, you're going to have lots of amicus briefs. You've got extremely smart law clerks who are going to read all of these. The Supreme Court doesn't have a massive docket, so they're going to read all of these. They're going to digest this stuff. So yeah, it matters, and you could always have the concession at oral argument or the weird oral argument that matter, or something really weird in the brief. But yeah, I don't see government briefs that are not well thought through, right? I mean, they may or may not be right, but they're well done at this level.
It's a more general question, but maybe salient to the audience. We've been told that the court doesn't know the origin of the Dobbs leak. Do you believe that's the case, or is this just a way of asking us to politely move on?
Well, Alito said that he thinks he knows, but not with enough certainty to make it public. So, different justices no doubt have different levels of certainty. But I guess they've made a collective decision that it would be irresponsible to say anything further. I don't know whether the investigation at the time could have been deeper, what you would have had to do, go through all the devices of the justices themselves, which may not have been done. But yeah, this is one of those things that likely we'll never know. No, at least none of us who are currently alive. It could be one of the justices has it in their files and will say it can't be released until 50 years after my death or something like that.
I mean, it is a tragedy that it happened, and Justice Scalia used to always have one of his clerks at least who was sort of a lefty, right? Because he liked to make sure he was getting discussion within his chambers. I mean, when I clerked for Ralph Winter, similarly, he didn't necessarily have one, but he wasn't that worried about the ideology of his clerks as long as they weren't way out there. He wanted, they need to be able to do the work, but he was confident in what he thought. I think it's going to be much, much harder for when trust erodes between, it may or may not have been a clerk, right? I don't want to assume it was a clerk. If it was a staffer or whatever, heaven forbid, right? But your confidentiality in your chambers is just so important to the integrity of this process, because you want to be able to be honest with your colleagues and your clerks and your team to get the best outcome possible. So it's really a shame that happened.
I think the public has largely moved on. I think within the judiciary, a lot of protocols have changed. I'm sure at the Supreme Court much more so than at our level, but definitely there's more security in terms of IT and things like that. But yeah, the main thing is it was just a historically.
All the discussions have moved to signal chats.
Are there reasonable chances that there will be a vacancy or two in the next year or two?
So Alito and Thomas are the oldest ones, and they're the ones most talked about, understandably thereby, are at the height of their powers and clearly enjoying what they're doing. You know, Thomas is the senior associate justice. Alito gets to write all of these great majority opinions. To the extent that politics plays a role in this, which, you know, it does somewhat. These people are not completely unaware, and they, you know, want their successor to carry on their legacy, presumably. They see that the midterm elections are shaping up such that it's very unlikely that the Democrats will take the Senate. House is a different matter, but the Senate. Now, and it might not be so persuasive to them to say, well, the Senate Republicans might lose seats such that the 50th vote that you need, you know, because you need 50 plus vice president, the 50th vote might need to be Lisa Murkowski rather than Mitch McConnell. Maybe that's not enough of a shift to push them. And to that extent, I could see, you know, really wait until 27 to look at Alito, and 28. See, if Thomas serves through May of 28, he becomes the longest ever serving justice. So essentially through the end of that term. So we could have a retirement right into the thick of the presidential election that year. Or maybe not, because Thomas might just be like, you know, they got to carry me out of here. That might be his attitude.
Are there any cases where there's a pending petition for cert that you've been keeping a careful eye on and hope the court grants and adds to the docket that's not already there?
You know, I file a lot of amicus briefs, and I get pitched on a lot of others, especially at cert stage. So I don't have them off the top of my head. Yeah, just look at the Manhattan Institute page and see what we filed for cert in the last 2 months, and those are probably good cases.
Yeah, the court just issued its orders list Friday and today, I think, from the long conference over the summer. I don't think everything is on there, and it's not uncommon. There's cases that are relisted, which means they want to look at, some justice wants to take another look at it, and so over the next few weeks, those may trickle out, but yeah,
The one notable case from the long conference, they granted half a dozen. There's a Second Amendment case. Not huge Second Amendment case, but something, whether a state can set as a default rule that you can't carry a firearm onto private property without the explicit consent of the owner. So how you set the default rule. They'll get a chance to elaborate on the history and tradition standard. I also should mention, if there's any prosecutors or criminal defense lawyers, hopefully not criminals in the audience, they haven't taken Fourth Amendment cases for a long time. You know, the criminal law professor Twitter, which is, you know, a niche, but has been apoplectic that there's nothing for them to chew on. But finally, they did take a case this term, Case versus Montana, it's called, and it asks whether there needs to be probable cause for the police to invoke the what's it called, the emergency chase exception to the warrant requirement, like if they're, you know,
emergency aid.
Emergency aid, yeah. So they're chasing a criminal, or they've got some, you know, the evidence might be disappearing, or something, whatever reason they have to avoid one of the exceptions to the warrant rule. Do they need probable cause to establish probable cause to invoke that exception? And there's been a number of these exceptions to exceptions. Fourth Amendment cases in the last 10, 15 years. So at least there'll be something for the Constitutional Criminal Procedure Academy to chew on.
A hypothetical. If any one of you were very close and influential to either Justice Alito or Justice Thomas, would you encourage either one or both to retire before the next presidential election? So we can get a justice of the same caliber?
I mean, I wrote, you know, my last book, Supreme Disorder, still available, including in paperback. Yeah, it was all about these sorts of issues. You know, politics has always been a part of judicial nominations, judicial discussions. You know, George Washington had a Supreme Court nominee rejected for political reasons, you know, all the way down. So I don't presume to tell these folks, you know, they know better than me. They can read the political tea leaves better than me. So they'll do what they're going to do. You know, if you were making that kind of calculus, then you'd look at I wouldn't say ahead of the midterms, but ahead of the 28 election, I would look at what is the chance of the Republicans keeping both the White House and the Senate. And if it's, not, reasonably good, then presumably, unless you're going to make that actuarial bet that Justice Ginsburg lost, can I survive another 4 or 8 years? Thomas, once he hits that longest serving mark, I don't know. At that point, he'd be like, oh, this is going to be fun. I'll leave them this to bat around during the election, and I'll go off and have my RV fun for the rest of my years. I don't know.
I mean, the right answer is if the president pre-committed to appointing Michael Park to the seat, of course we would encourage them to that.
Well, that's the other thing. Are there going to be these back channels, Justice Alito, we commit that we will appoint one of your former clerks, Andy Oldham, say, or Justice Thomas with Naomi Rao or Jim Ho. There's lots of former Alito and Thomas clerks who are very credible shortlisters. So,
Any final questions? We have time for one more. No? Okay, well, please join me in thanking our panelists for a delightful conversation. Thank you, everyone, for attending.